My name is Taylor Ott. Welcome to another episode of Level Up Law, where every Tuesday at noon, SC Legal Services levels up your knowledge about an area of law that we practice in. Normally, Susie Ingalls is here to do the introduction, so today I'm introducing myself as she's in court this morning. Like I said, my name's Taylor Ott. I'm a staff attorney in the Orangeburg office with Legal Services, and I also serve as the firm's elder law unit head. And as always, our producer, Kenneth Elliott from our IT department is here as well. This month, we've been doing a series of Level Up Law presentations on Older Americans Month. And today we'll be talking about the top 5 legal issues for older Americans. Before we get started this morning, we do want you to know this is not legal advice. It's just general information for the public. If you need the help of a lawyer, call our intake line here at Legal Services, and the telephone number for that will be on the last slide of the presentation, or apply online. That way, you can get in with our firm as a client if you have an area of law that we practice in and you're eligible under our guidelines. The information that will be provided today as far as the intake application number and the firm's website will be at the end. And as a reminder, all of our episodes are posted by Kenneth Elliott, our producer, to our Level Up Law playlist on YouTube, usually within about 24 hours. If there's anybody present today who has questions, I can answer those at the conclusion of the presentation. Put any questions you may have in the question box, not the chat box, at the bottom of the presentation screen. So today, I'm going to be talking about the top 5 issues that face older Americans. Okay. So in general, when Susie and I were talking about how to kind of finish out Older Americans Month, we talked about over the last, almost, I guess, in excess of 2 years, these presentations have gone on. We talked about what are the things that we really think people should kind of take away. The purpose of today's webinar is just to kind of make you aware of what we've talked about in the past. If you have specific questions or want more information about the topics we're discussing today, I believe almost all of them, we have additional webinars from the Level Up Law series that go into further information about those topics. So if I don't cover it or I can't answer a question today, this is more just a real brief presentation over what we would consider people to be aware of who are a little bit advanced in age. So these tips are not necessarily separated by areas of law. It's just sort of if I was advising a client who might be planning for retirement or retired or caring for a loved one who is a little bit older, what were the things I would want them to pay attention to? So the first tip that I have is be wary. There are a lot of things that seem better than they are, and I always talk to family members about how I get more suspicious of things I didn't even know I should be suspicious of the older that I get and the more that I practice law. Because as we become more experienced in life and we learn about things and we experience things, we realize there's actually more out there to be careful of. So this one actually is in relation specifically to property and how the theme of Older Americans Month this year is aging your way. And I believe that in prior celebrations related to elder law and that sort of thing, there also had been this idea kind of geared towards allowing people to age in place. So one of the typical things that you may desire as you're planning for either retirement or end of life care, you're going to want to stay in your home, especially if you own that outright and there's no existing debt on the property. You're going to want to stay in your home versus maybe having to be in a nursing home or other types of long-term care. So the thing that kind of comes to the top of your mind and your ability to be able to do that and afford the costs that increase as you age, maybe your reverse mortgage. And in general, the takeaway here is they're not really as great as you think they are. They are advertised and packaged usually as the ability to stay in your home and get the equity for what it's worth, and you don't have to pay for it as long as you remain in the home as your primary residence. And that's not actually true. Depending on how the reverse mortgage is structured, you may be able to get some of the value out of your home, but there's a cap. So depending on the program, and let's say you had a home that's worth $100,000 and you had no debt attached to the home, no mortgage, no other liens, You could sell that home if you sold it for $100,000. That's how much you'd have in hand. There'd be nothing where you'd have to satisfy existing debt associated with the property. A reverse mortgage would not allow you to tap into 100% of that equity like you could if you sold the home outright. There's going to be a cap of how much equity you can tap into, and that could be 50%, it could be 60%. So that means that all the money you'll ever get for the value of your home is going to have a cap on it because of that reverse mortgage. And then you can get a lump sum paid out to you within a certain period after you close on the reverse mortgage, but then you have to pay that lump sum back. So it's not they give you 50 or 60% of the value of the total equity in the home and then allow you to stay there. It's what value do they get? And it's you're paying that lump sum back to them at some point. And it's probably going to be less than the mortgage payments you first paid to purchase the home, but it's still going to have the potential for balloon payments associated with it, where they can call that debt due after so many months of making payments. Probably going to have a high interest rate on it. So reverse mortgages are popular because they don't get into all of those details. If you've ever seen commercials about it or kind of talked to somebody who's not the mortgage broker about a reverse mortgage, they're going to give you all the great details, but not going to talk to you about the fallback. There's also, just like a traditional mortgage, there's going to be costs associated with the closing, having to pay for the attorney, the closing costs. All those are going to come off the top of the pot of money. That cap of 60% or 50% is going to come off the cost you're also going to have to pay for, and interest. You're not just paying back the amount you borrow, you're paying back the amount you borrow against the value of the house, plus interest and fees and servicing and all that. So just realize when you're thinking about how to age in place that you consider reverse mortgages might be something that you should be a little bit wary of. The next thing when it comes to property ownership, as far as how people might, if they have not owned a home or they're trying to buy a home, they may do what's called a contract for deed. Different than a owner finance mortgage, different than a mortgage where somebody holds the debt. It's you agree to make payments, and at some point those payments, that they might be rent, those payments, if you keep making them, eventually that person that you're making the payments to, who hopefully actually owns the land, will transfer ownership of the property to you by signing that deed over. With a traditional mortgage, though you're making payments, the deed is already in your name. You're just making payments under a debt secured by a note. That's the mortgage agreement that you sign, which says you have a contractual obligation to pay all these things back. So contract for deed is a little bit different. So that's one of those things, again, may seem better than it really is, but a lot of people end up having to do contracts for deed because maybe they can't qualify for a mortgage because of their credit or payment history or other things they may have that limit their financial ability to qualify for a traditional mortgage. And then another way that people, as they age, may be planning to live on would be living on family land. And nobody's alive who owned that property, and the last person who actually had what we call deed and title of the property died more than 10 years ago. So that's what we call heirs property. Real common in my area of the state, down in the low country. There are, you can drive around and the tax assessor may have a family member listed as the owner of that property, and that family member may be paying the taxes. They don't actually have legal ownership of the property. So the family could all agree who's going to live there, who's going to pay the taxes, who has the right to build a piece of property there. But you cannot leverage heirs property in the same way that you can traditional real estate, as far as being able to realize the equity in that property or being able to sell it. So you could make improvements to heirs property. So let's say it's your mom's land, she dies, you believe you have an ownership interest in it, but your mother's been deceased for more than 10 years, and you can pay cash for a mobile home or modular home on that property. You don't have to finance it. But 10 years down the road, you're trying to sell the property and sell that, that home can't be moved, sell that home with the land. You realize at that point you don't actually have ownership of the underlying property to be able to sell it. That's because it's heirs property. To clear that, you're either filing an action in probate court or civil court, depending on what county you're in and how old how long it's gone without somebody's name on the deed. We have other presentations, I think some of which Susie has done in regard to heirs property for additional information about that. The big takeaway here is you have to be very careful when you're making plans in regard to where you're going to live, that you need to understand what are the ownership rights you have in regard to that property, and can you really use it the way that you think that you want to. So this is kind of my bread and butter of the practice that I have with legal services, is helping people as they age be prepared for what may happen in the future. And so I've done a couple of different presentations over the years for Level Up Law in regard to advanced directives and estate administration. So there's a handful of documents where you can let loved ones know what your wishes are prior to death, whether you're doing that in a power of attorney or a healthcare power of attorney or a living will, letting your loved ones know what your wishes are in regard to end-of-life healthcare or financial decisions. All of that, you're either leaving directions or appointing somebody in a document to make those decisions for you or make sure your wishes are followed. That is something that you, I would encourage you to have the representation of an attorney to prepare those documents to make sure that your wishes are actually put in that document in a way that it is also validly signed and witnessed and notarized if that's a requirement, so that those wishes are legally binding in the event that had to go to court. So you want to be prepared. You want to leave more than just breadcrumbs for your family to follow if you are not unable to communicate your wishes, maybe because of a medical condition you have, or you have a treating physician who declares you incapacitated, which is you may be able to communicate and express your wishes, but those are not in your best interest, that you're not able to make reasonable decisions. So you're going ahead and speaking now for the wishes that you have in an event in the future. So in those documents, you can say, if I have a terminal condition, I do or do not want nutrition and hydration to be withheld. I do or do not want life-sustaining treatment. Those also are difficult decisions to make and to express in the moment of the emergency. Estate administration, that would be you are preparing a last will and testament, naming who you want to have to deal with, filing all the documents in probate court and making sure your wishes are followed after your point of death. And also, you may be involved in the estate administration of a loved one. So as you're considering your own plans, if we have clients that we're helping get appointed as a personal representative and deal with that estate administration process, if they are not already have estate plans lined up, that's one thing that we encourage them to think about or allow us to assist with, is having a last will and testament prepared for them, so that, especially if they're going through what we call intestate or an administration where there's not a will left behind leaving wishes about how things are supposed to be divided or who's supposed to go to court with the information and fulfill the duties as the executor of the estate, that maybe you don't want your family to have to go through all of that and you want to be a little bit more clear about what your wishes are. That allows us to step in and help prepare the documents associated with estate administration. I really encourage clients, if they come in and they decide they don't want to do any advanced directives with us, or maybe they want to consider what they want to put in their healthcare power of attorney in regard to their end of life care, I always tell clients they need to go ahead and have those difficult conversations with family members now. So there are ways in which your immediate family is going to be able to make decisions about your health care at the end of your life, whether or not you have a healthcare power of attorney. It could be through the Adult Healthcare Consent Act. It could be through a court appointing them temporarily or long-term as a guardian or conservator for you. But an obligation in all of those situations is to at least try to follow the instructions or wishes that you have to act in your best interest. So how is a loved one down the road supposed to know about what your wishes are unless you have those difficult conversations with them now? So that doesn't have to be leaving behind a written manual about how to care for you, though I've had clients in the past where that's exactly what they do, and it does prove to be helpful. It's at least having conversations about your values and what you would want to have done for you if somebody else was making decisions, or how you would want them to arrive at those decisions. What voices would you want to be in the room? So you need to be prepared. You also, as you are dealing with legal issues as you age, you need to be defensive. And what I mean is you need to assume that it's if something happens, not when. Specifically, when I was drafting this particular slide, I was thinking about consumer issues and fraud and financial scams. But you need to assume and be defensive in regard to information you're sharing and how you're putting that information in, whether it's using the internet or purchasing stuff over the phone or allowing you know, maybe grandkids in the house that are having access to your money and your social security card and all of that. Don't assume it's not going to happen. It's an if, not a when. I'm sorry, actually I have to put that inverse. It should be it's when, not if it happens. I'm sorry. So that's actually backwards. So you should assume it's going to happen to you at some point. And so you need to be defensive. You need to identify the helpers that exist in your life. And so when I was thinking about this, it's who do you trust? What are those trusted resources as far as information? Do you, when you're getting information about whatever it may be, if it's a new, if it's a medical treatment you're going to undergo, if it's a financial decision you're going to make sure that the resources, again, those voices in the room, make sure that those are credible. One of the things that usually happens when somebody is financially exploited or when somebody else can influence the decision making they have, it's not necessarily at the beginning of that relationship. It's fraud that occurs over time, and that they have developed this rapport with, the perpetrators developed this rapport with the victim over the years or months that they may have been committing this fraud. And you need to be pretty discerning. Again, be defensive of when you're identifying those people you're going to allow to help you. You need to be defensive in how you do that. Don't let everybody in. There's a teacher that I had one time that was talking about how gates in a fence can be offensive and defensive. It's both what do you let in and what are you keeping out. So have your fences, use those gates. You also, again, with resources, where are you getting your information from? I think we live in a world now where it's ever increasing the number of people and voices that we have access to. When I was a kid, it was, I think there was talk radio, but it was AM and FM. Sirius radio wasn't a thing. There wasn't YouTube. So there's a lot of information that you can take in that can be difficult to filter through. So just when you're looking at websites, do they end in .gov, G-O-V, indicating that it's a government-run website? Is it a .org, where that has to be some type of registered nonprofit? Are you getting things that might be foreign news and correspondence? Just try to, again, that same teacher that talked about gates always talked about you should give the opinions the consideration which they're due, which doesn't mean that you have to believe everything you come into contact with. Again, be defensive. Give that information or that opinion the consideration it's due. And so it doesn't mean you have to listen to it. It's, is this trustworthy? Is this coming from something where that person has my best interest at heart? Or is this when that fraud occurs, right? Because it's not if, it's when, inverting that first phrase in that slide. So tip 4 is be ready. So when you're doing, some people refer to it as estate planning, where they meet with somebody and they're trying to figure out what Medicare and Medicaid programs they may qualify for, which this is going to be a plug for an organization called SC Thrive. They help screen and complete applications for public benefits programs you may be eligible for based on age and income level. So it's a little bit different than what I'm talking about now, but if you're trying to figure out how do I even know what I might be eligible for based on who I am and where I live, SC Thrive is a great organization, and we should be able to get a link to that in the description to the YouTube video when this is posted. So two things to think about when you're planning for the need to have some type of assistance in regard to paying for your health care. There's a Medicaid look-back period and then a Medicaid estate recovery. So the look-back period is that 5 years before you try to establish Medicaid eligibility, they will look at to see, during that 5 years, did you transfer any assets you owned, chiefly real estate, but did you transfer any assets that you owned for less than fair market value to become financially eligible for Medicaid? So 5 years is a very long time, and that definition of less than fair market value, you may say, well, what are you talking about? So let's say you own your house and it's primary residence. It may not be worth very much money, but you want, as part of, maybe an attorney recommended this to you, maybe you should go ahead and transfer that land to who you want to own it before when you die, but go ahead and do it now and do it via a deed. It's usually called a quit claim deed, not quick, Q-U-I-T. And that's where you're transferring a deed, but you're not doing it in the same manner of what we do called warranting title, where you're saying you're just transferring, it's a deed that's drafted where nobody's going and paying a title abstractor to go and make sure that you actually legally own that property. It's just the way of documenting with the register of deeds or deeds office in the county where you are, that ownership of that property by deed is being transferred. So it's just a type of deed, not the kind you would get if you're buying a house with a mortgage and a real estate broker and all that. So with the look back period, they're looking to make sure during that 5 years, did any of the deeds or other property transfers indicate that you were selling it or transferring it to someone for less than fair market value? So they would go and they would look at the documents associated with the transfer of that land, including the quit claim deed itself, and are they going to be able to see that you transferred it to your son without any money changing hands? And sure, the deed might say $5 love and affection. It's one thing if you sell it and money actually changes hands. It's another thing if you're just transferring legal ownership of it and nobody's purchasing it from you. So this doesn't mean you can't sell property. It just needs to be, is it for less than fair market value? Fair market value is a fact-based determination based on your particular circumstances, but certainly if you're selling a $100,000 piece of property and you're transferring it for $5 love and affection, we can clearly say that that's for less than fair market value. So if you transfer property in that way in the 72 months prior to becoming eligible for Medicaid or applying for Medicaid, they're going to potentially find you not eligible, and you will have, as a penalty, you'll have to go maybe several months without being eligible for Medicaid benefits. And then Medicaid, when I do presentations on Medicare and Medicaid, I always say that, especially when talking about these two things, federal government always wants to deny people public benefits and then always wants their money back. So keep that in mind. With a Medicaid estate recovery, after somebody who received Medicaid benefits dies, Medicaid will try, does not always, but will try to recoup or get back, claw back money that they paid on behalf of that person during their lifetime while they were Medicaid eligible for Medicaid expenses. They try to get that money back from that person's estate. And the estate would be whatever assets they owned after their passing that are still in their name that have value. They're going to try to get money back. So if they paid out $10,000 in nursing home care, they're going to file a claim against the estate for that $10,000 to pay back. And that could be that that person has enough money in a checking account to satisfy that claim. It could be that it's a lien attached to a house, because usually people who are eligible for Medicaid have certain things that they can own and still be considered eligible for Medicaid, and one of those is a primary residence. So again, we go into Medicaid estate recovery, I think, in other level up law presentations, but just in general, just realize that just because you're eligible for Medicaid and they're paying for things during your lifetime, and you have estate planning at the end that, I told you earlier, you need to have a will naming who your heirs are and who you want your things to go to. You can have that, but you can't prevent Social Security from trying to recover the money they paid out on your behalf through Medicaid. There are ways that it can be waived. There are hardship petitions. There are ways of dealing with the amount they're trying to collect, but that's just a thing to be aware of if Medicaid eligibility is in your future or you're currently receiving Medicaid. Just be aware of the potential for estate recovery. So that's tip 4, which is be ready. And the last tip, which is sort of related, is, oops, sorry, I went backwards, is tip 5, which is be knowledgeable. So this one in particular, I was thinking about kind of the idea of aging in place and how do we achieve that goal. And so it's both, what are the long-term care options? That's the second part of the slide. So when you're looking at, there are people who are long-term care planners. Those are maybe not necessarily attorneys, but they're people who understand Medicare and Medicaid eligibility, can help you plan financially for long-term care, especially if that's not going to be through income-based programs. So there is a whole website through, so you can access it either that first link or longtermcare.gov, which will give you kind of general 40,000 foot view of what long-term care is, what options are out there in general, and these are available in South Carolina. There are what we call PACE programs. The one here in Orangeburg, there's a bus that drives around that says PACE on it, and it's run by a local nursing home in town. So that's a program of all-inclusive care for the elderly. So it also will sometimes be referred to as like day programs. Those are people who, I think there's a slogan, I don't know if it's the one in town or if it's the one in Columbia, and it's like something about enjoying their care during this day, enjoying their provision of care during the day, but the comfort of home at night. That's not the slogan, it's much more catchy than that. But this idea of even if you're living independently and nobody's taking care of you, it's somebody to drive you to and from the doctor. It's somewhere where you are during the day, where they provide some of the meals you have. Then there are housing options that are, hospice or respite care. So that might be provision of medical services in your home if you're deemed eligible for hospice, which is usually that they expect that you'll pass away within 6 months. And then respite care might be you're in the home of somebody that's providing care for you. Maybe you just have some medical issues, but you're still able to take care of yourself. And that respite care is you go somewhere temporarily, and maybe again, a day program. It could be overnight to kind of give the caretaker who's providing care for you a break. That's what respite is. Accessory dwelling units, this is kind of the trend in my area of the state for families that can afford it, is there may be like a family land where there's a main house, and then there's like a she shed in the back. That's what we call them in my office. But it might be you've seen storage units turned into these. It could just be the whole like tiny house thing where it's, you might traditionally have a house that's built where there's a mother-in-law suite, where your grandmother, as you grow up, lives in the house with you, but she's got her own entrance, her own kitchenette, own, kind of separate part of the house. This is that same idea, just a little bit different, where it's literally its own separate dwelling unit on the same property. It can't be sold separately. You're not partitioning off the property, but it's either secondary to the building of the main house, or they're built together. And then there's senior subsidized housing. So depending on where you are, there may be programs that are either reduced rent or what we would traditionally call public housing, that are specifically for people who are 60 years old and older. And we have one where I live down the street from my house. You wouldn't even know that that's what it is when you drive past it, except it has something on it indicating that it's senior related housing. And then this is a plug again, just for another organization. So the South Carolina Department on Aging has a ton of different resources available on their website that are specific to South Carolina. So it's now, the website is aging.sc.gov. Again, we'll put a link in the YouTube description. So you may be thinking, what is the Department on Aging? How have I ever interacted with the Department on Aging? So the Department on Aging has regional, local area agencies on aging. We call them AAAs. And so those cover regions in the state. Here in Orangeburg, we're covered by Lower Savannah Council on Aging. That's out of Aiken, but they also serve Orangeburg County. And then counties also will have their own individual county offices on aging as well. But those are the programs that coordinate things that you've definitely heard of. Meals on Wheels, big deal. You've probably, the logo, at least for the one here in Orangeburg, if I come into work early, I can see and start driving. The county office on aging is a street over, and they start early and they go all day. So Meals on Wheels is great because it allows them to provide meals to people who qualify that might be homebound or recovering from a medical event. But it's also great because it's eyes of the volunteers on people, and so they can help provide other services for them as well. So Meals on Wheels is kind of a daily putting eyes on somebody who might be in a circumstance where they're living on their own, but may need some help or to be identified as help. The AAAs offer legal assistance. That's like a small part of what they do. Kind of an unknown part is they can help coordinate services through a grant, and partially that's through legal services. We call it our 3B grant. And then within the Department on Aging is also a program for, it's called Long-Term Care Ombudsman. So if you or a loved one was ever in a nursing home or some other long-term care situation, maybe outpatient or inpatient rehab, and you had complaints to make about the services you're receiving, or really just needed to kind of talk to somebody who's not in the institution where you are, the long-term care ombudsman is that voice for you. It's that person you can call. They have a process of investigating the claims that you have, can make you aware of your rights. And so that's another important thing that the Department on Aging does. And then they also have a whole other branch, a host of services we're not talking about today. The Department on Aging website is wonderful. So that is the brief presentation we had prepared for today, just to kind of cap off on what we've done and tie into some of the other Level Up Law presentations that we have. And I don't think that we have, let me just make sure, we don't have any questions that I know of, and there's something I'm supposed to read when we finish, if you'll bear with me. So that's the conclusion of today's presentation. We'll post a recording of today's episode on the YouTube channel. Just look up the Level Up Law playlist when you go to our YouTube page. Share the video if you found it helpful. And while you're there, you can also subscribe to our channel and sign up for notifications so you'll know every time we post a video. Also, be sure to check out our social media and get all the up-to-date information we provide on Level Up Law and other resources. Those websites and social media handles are actually here at the bottom where it says stay connected and then resources for the general public. Also here is the telephone number for our legal aid telephone intake service. So if you thought, well, some of the stuff that Taylor was talking about today, I might be interested in seeing if I qualify for legal services to help me with that, you'd first need to call our intake line and be screened for eligibility. So that telephone number is 1-888-346-5592. And that telephone line is, they handle calls Monday through Thursday, 9 a.m. to 6 p.m. And you also can apply online for certain areas of service by going to either our website, which is sclegal.org, and then there'll be an Apply Now button, or by following the web link here under Apply Now. And be sure to tune in next week for another episode of Level Up Law on Tuesday at noon as we conclude our observance of Older Americans Month. Thank you for tuning in today on Level Up Law, and that concludes today's presentation.